have two cases scheduled for oral argument this morning. Our first case is Mamadou Quadrago versus Walmart Stores East. Is counsel ready to proceed? Counsel, we will allocate 20 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes for rebuttal.
So noted, Madam Clerk. You may continue.
Thank you. May it please the court. My name is Brian Lee. I represent the appellant in this case, and Your Honor very aptly, thank you, very aptly said his name correctly. I am not as good at saying the name, so I'm going to call him the appellant in this case. But Mr. Oragu was the plaintiff in the underlying case, and the trial court granted a summary judgment for Walmart that we have now appealed to this court. And the reason we've appealed it is because we believe the trial court overstepped its bounds in weighing evidence, as well as finding that there was no duty that Walmart had to Mr. Oragu for this particular incident. The evidence that was put forward in front of the trial court was entirely from our side. Walmart did not include any evidence in its motion for summary judgment, but we did. We included evidence not only that consisted of surveillance video of the Walmart store in question, deposition testimony of Walmart employees, obviously the deposition testimony of the plaintiff himself. And so we believe that when you look at the evidence as a whole, there was evidence there that the jury could have determined or made a verdict for the plaintiff. And that is what the standard is now for the summary judgment.
So there's no issue of actual knowledge?
That's correct, Your Honor. This is a constructive knowledge case.
Okay.
Yes, and there was no evidence that that any of the employees of Walmart actually saw the banana peel. No one testified to that. It is the proverbial banana peel in this case that the slip and fall happened. But what we do have is we have constructive knowledge.
And what evidence in the record supports your argument concerning constructive knowledge?
Two main categories of evidence. One is that the peel was on the floor, and we know this from the video, for at least 8 minutes of time. A little bit more if you kind of parse the seconds of the video, but it's above 8 minutes.
Is that element alone sufficient to support your argument regarding constructive notice?
I believe it is. And the reason is because under the statute, which both sides have cited, the constructive knowledge can be shown when a condition, in this case the foreign object, was on the floor for a length of time that in the exercise of ordinary care, Walmart should have known about it. And we believe that the case, now, I will note, obviously, and you've seen the cases from both sides. There are some cases which say it's 10 to 15 minutes. There are some cases from federal court that say, really, there is no bright line rule, and it has to be sort of a case-by-case thing. But a court shouldn't say that there's a bright line rule, meaning 2 minutes is not enough, but 5 minutes is. And so we do believe that when we pair that evidence of how long the peel was on the floor with then the evidence of Walmart's employees having the ability to see it, and we believe that there's evidence that could support that.
And what evidence is that of record?
Sure. And so what we have is we have two sets of evidence. We have the surveillance video itself, which shows the trackings of Walmart's employees in the store where they were. The particular one that I'm talking about pairs with the deposition testimony that we have of one of the employees of Walmart, and I'll give her name, Miss Barton. So Miss Barton was in the front of the store. Her and another employee are stationed at the front of the store. The place where this happened was right next to a bin, which is right past the front of the store. Ms. Barton testified in her deposition that Walmart's policy was to have at least those two customer hosts at the entrance and exit, that there were two hosts, including herself, and she testified that, and the video shows that she was there after the fall. So it wasn't like this was a situation where she was way far down an aisle or in another part of the store. She was there. And what she also said, and what I think is very poignant for the court to consider, is she was asked specifically about her line of sight, because there was a lot of there was some findings in the trial court's order about, well, employees would have to turn their head 90 degrees to see it. She said specifically in her deposition that her post was the entrance and exit. She would be looking into the store, and she could see all the way into the store. So, and this wasn't a situation, again, where it's all the way on the other side of the store. It's near her. And so when we're...
Didn't she testify that looking for stuff on the ground was not part of her duties?
Yes, she did.
She never received any training or instruction?
She did. And there's also evidence where, Walmart trains, right, to look at things, and but there's the fact that she says, well, it's not part of my job, doesn't necessarily mean that isn't something that she should have done. And
so your argument is that should have been part of her job. It should have been part of every employee to look for hazards as they're going about their normal duties.
Correct, and there's specific cases, and I think there's a Winn-Dixie case that versus Marcotte that I've cited too, that talk about it's not just a premises owner and by relation their employee's job to know of a dangerous condition. It's their job to go out and actually be proactive. It's not just reactive. They know about something, they have to do something about it, of course.
Counsel, on the other hand, the appellee cites the 4th District's opinion in Oliver versus Winn-Dixie Stores Incorporated in support of their argument. Can you distinguish the Oliver opinion?
Sure, and I do this in my reply brief. Oliver is a situation where there was evidence in Oliver, if I'm remembering correctly, that there was an employee that said that, and I forget it was a he or she, but the employee walked past the specific area that Oliver slipped on a substance and fell on, and said specifically, I walked that area, I think he said 3 or 4 times, and there was nothing there. Okay, so there was direct evidence of an employee of that store saying that I was in that area and there was nothing there. And so in this case, obviously, there is none of that testimony. We know that there was something there. We could see it on the surveillance video. This isn't a situation where the plaintiff says, I slipped and fell on a puddle or water droplets or something on the floor, and everyone else says, we didn't see anything there. There is very clear that there was this foreign object, this banana peel, on the floor for 8 minutes. There is no testimony from any employee that says, I went past that area and I didn't see it, because there wouldn't be. It was there. And so Oliver is distinguishable from that, and I believe if you look at that case, the 4th DC really put a lot of emphasis on that testimony. And so when we talk about what testimony or what evidence is sufficient to go to a jury, a trial court can't look at the evidence and then weigh it. Can't look at the evidence.
Several years ago, the legislature basically changed the standard to go to the federal Celotex standard.
Right.
And so some of your argument sounds like it's applying the old standard. You have some old cases, you have some newer cases, but I'm wondering where this fits on the spectrum and what the actual standard is since it's changed and how we should apply it.
Sure. So the statute was changed, as obviously the court knows, and prior to the statute, there was this line of cases, and because the statute didn't say this, knowledge was not an element of a transitory foreign substance case, in the sense that if you proved that Walmart was negligent, they didn't have any inspections done. It didn't really matter whether they then also had actual or constructive knowledge. You could bring a case and even survive summary judgment without having any knowledge whatsoever, just because of the fact that Walmart didn't inspect correctly or at all. That was something you could bring. when the statute changed, and I think this is borne out by the cases, and Oliver talks about this. Oliver talks about that now what we have is we have a premises negligence case with an added element to it, that you have to now show that notice.
Counsel, when
that
you refer to
knowledge.
the statute, are you referring to section 768.075?
Correct, Your Honor. And so it says that you have to prove either actual or constructive knowledge. Actual knowledge this court has already dealt with before in Whitlow. But constructive knowledge in the statute is different. And it says that it shows ways, right, for you to do that, but as one of the ways is to show regularity. If it's a regular condition, then that is the way you show constructive knowledge. The other way
Is
to
there
show...
any evidence in the record that banana peels occurred regularly on Walmart floors?
No, there's no evidence of record that the regularity component was what was sought, and there was evidence of that. But the length of time argument is there, and it's not the way that the statute is written is that it doesn't just say that it was there for a length of time, so they should have known about it. Number one, it doesn't say what that length of time is. They could have certainly said that if they wanted to. If they wanted it to be less than 10 minutes, they could have said 10 minutes or more. Or some type of number, but they did. They said a length of time, but I think that the middle part of that statute, that section of that statute is important because it talks about length amount of time on the floor that in the exercise of ordinary care, I believe that's the words that it shows. And so it includes that element of what previous cases we're talking about. Those common law duties of care that a premises owner has to do. Those include things like inspection, how you operate, maintenance.
Why does inspection matter? So the statute
Right.
speaks in terms of knowledge, and which then I guess presumes if you do duty, breach, causation, and damages. I'm assuming the duty is you're a premises owner and you have invitees, business invitees, and there's an expectation that the premises is going to be safe for people.
There's two normal duties. The premises owner liability duties are duty to maintain in a reasonably safe condition and do to warn people who come in of things that are known or should be known, right? So there's those general common law duties that have been around for a long time,
Right.
that they have there. How that juxtaposes then to the statute is the statute doesn't say that that's gone now.
Right. No, but the statute expects that it be proven
Right.
that the premises owner have knowledge.
Right.
Now, it could be actual knowledge, which would be had that employee turned her head 90 degrees and seen the banana peel. That would have been actual knowledge, right?
Correct.
That didn't happen, but for some reason the parties were arguing about that a bit. I don't know why that's relevant, because this is a constructive knowledge case.
It is.
And in fact, the summary judgment motion framed it as purely a constructive knowledge issue. And more specifically than that, it characterizes just the duration of time. So, and they don't submit any evidence in connection with their motion. So why isn't the motion on its face defective if it asserts that the plaintiff hasn't brought up evidence or it hasn't come out in deposition that the banana peel was on the floor long enough, and that is from the motion, and that's what framed it. Isn't that enough? Isn't that by itself defective? Because that's asking the judge to make a fact determination as a matter of law.
I agree, and it's not just that. It's that the motion itself doesn't include any evidence whatsoever. There's no record evidence that I am aware of, and I looked at it again, that is part of that motion. Nothing. And so and I've listed the case law, and a lot of it obviously is from the federal realm now. But
I mean, basically the motion was a challenge to you
was
to
challenged.
put up
It
or
says-
shut up, which is what the standard is now, basically.
Right, but the standard also doesn't all the way do that. The standard does say that motions for summary judgment, at least how I read the cases, there has to be some basis for the defense to say that you're not doing. The defense can't just, at least as far as what I see, they can't just do a sentence motion that says plaintiff can't prove their case on the top of summary judgment. It can't do that. There still has to be a showing that summary judgment is warranted. Okay? And so that didn't happen in this case. There was zero showing.
Well, let me turn it around the other way. Under what circumstances could there ever be a summary judgment in a slip and fall with constructive knowledge at issue?
I think in the same way that, in Oliver, I mean, we've been talking about Oliver as a case. Oliver talks about a situation where there was constructive knowledge of it. But the underlying, the underpinning of constructive knowledge is that everyone agrees that there was something there. That there was something there on the floor, and they should have had constructive knowledge of it. Oliver tells us that when there is this discrepancy as to whether there was anything there, the plaintiff has to prove that first.
Sure.
Okay, and so.
But
and
assuming that something is there.
Assuming something's there, right. I think, and Your Honor, this is just my thought, I don't think in a constructive knowledge case, if there is evidence presented by a plaintiff that would either show a length of time that it was there, or the things that were there, I don't think that's proper for a court to enter a summary judgment, because the court would necessarily, at some point in that continuum, have to weigh the evidence.
And do you think there's a constitutional right to have summary judgment granted?
No.
So if there was a situation or a particular type of case where it's unlikely that you could get summary judgment on an issue, that isn't constitutionally problematic, do you think?
It is, and it certainly juxtaposes against the constitutional right to a jury trial and the Florida's sort of I mean, this court talked about that in its decision.
Whitlow addresses that.
In Whitlow, obviously. Obviously, Whitlow was talking about an actual knowledge situation. And I took a look at the oral argument, and there was a lot of back and forth regarding the fact of whether or not the plaintiff had the foundation to do an affidavit. But this court never reached that, because it found that, look, there wasn't any evidence that the person knew about it. But I would wonder what happened if there was. And because then, even in that case, now you're getting to, when you're starting to now have a court look at an affidavit and determine whether it had a foundation, or in this case, whether witnesses' testimony or whether someone could really see that in a picture, we are now skirting into what a jury does. And certainly under the statute, it does not absolve a jury of doing exactly what they should have done in this case.
Would it have been a matter of law if the banana peel had been on the floor for just 1 minute? The trial court to make the determination?
No, because
Why not?
I don't think that, again, matter of law, there's nothing in the statute, it just says length of time. And so there's nothing in the statute which tells you, me, this court, that this amount of time is presumptively, well, they wouldn't have been able to do anything about it. And I think that's because of the fact that it is joined with what they did or what they didn't do. And it's also joined in the practicalities of today's age where, yes, we do have Walmart, which may have 20, 30 aisles, but we also might have a small business establishment that has one.
So is it your position that in any case where the issue involves constructive knowledge, it is always a question of fact for the jury to determine as opposed to the court to determine?
My answer is yes. If the plaintiff presents evidence that can prove that that substance, object was on the floor for a length of time, and can also pair that with evidence that either they should have known about it and they didn't do it, they didn't do inspection, didn't do maintenance, anything of that sort, that is the quintessential jury question. You cannot enter summary judgment in
isn't it a little bit more complicated than that, though, with the new summary judgment? It's not really new. I mean, it's new for Florida, but it's been around for a while.
Right.
Probably 100 years, I think.
Sure,
But
and
so,
I'm sorry, go ahead.
But isn't it more complicated in the sense that we're taking for granted the fact that you have a video?
Right.
And I mean, it's conceivable that someone could look at a video and conclude that no reasonable juror could look at that video and conclude that that was enough time. Possible. Under those circumstances, let's say it's it's in a back corner somewhere,
Right.
Obscured, and it's there for a minute, no one's passing through there, and it just so happens the person that slips and falls, they just happen to be there, but no one else goes there. It's off the beaten path, so to speak. And conceivably, if that was your only evidence in response to a summary judgment motion, a judge could look at that and say, there's no reasonable juror would conclude, which is the standard now, it's directed verdict standard.
Right.
No reasonable juror could conclude from that evidence and go your way. Versus this situation where you have a video where it's more wide open and there's lots of other things going on that makes that question more complicated. So I don't.
No, I understand what you're saying.
It's really not categorical.
I understand what you're saying, Your Honor, but I think in that situation, there wouldn't be the paired evidence. There would be a length of time, right? We could see a banana peel, if we're talking about that, in a corner of a room there for an hour. But there also wouldn't be a paired that either there were people around it that could have saw it, or that there was an inspection done or should have been done within the certain amount of time. So I think, yes, correct. If there is a situation where they were inspecting all the time and then the banana peel happens in a corner, right? I mean, there are situations that I think that the federal summary judgment standard does give a judge the ability to do that. But I just think in this case, with the evidence that was before, the trial court went too far.
Thank you, counsel. Your
Thank you.
time has expired. However, I will give you an additional 3 minutes for rebuttal.
Thank you.
And I will also extend counsel Appley's time by an additional 3 minutes.
Thank you, Your Honor. May it please the court, Daniel Weinberg, Lux Santinello, on behalf of Appley Walmart. I guess I'm going to start right where the questioning was kind of ending, on the quote-unquote new summary judgment standard, which, as Judge Tenenbaum correctly stated, is really just new for Florida. Regardless of whether or not when Walmart moved for summary judgment in the trial court, they got into all the details of what was in the videotape or not. Under the new standard, the non-moving party bears, or when it's their claim, bears the burden of production. It's meant to help move cases forward. And plaintiff came forward with evidence, primarily photographs and a videotape, that I don't think is really fairly characterized in the briefing anyways, except for with respect to one employee that kind of was walking on the other side of the bin where the banana peel had existed. And
But the video is in the record, though, right?
The video is in the record, and
we're allowed to look at it just the same as the trial judge looked at it.
Absolutely, absolutely, and I think if the court does look at it, some of these other camera angles that are being discussed, I don't think it shows. I don't think it shows what's been stated as far as the eye line of the other employees, to the extent that matters, anyways. And our position is under 768.0755, and as stated by the court in the Alford decision, which even though is slightly factually distinguishable, the law is pretty clear that constructive notice under the statute can be proven in 2 ways in a transient foreign substance case, unlike when we're talking about a static condition where maybe other avenues would be open for proving liability. And that is the passage of time and a regularly occurring condition. Regularly occurring condition is conceded, not an issue in this case. It's strictly about the passage of time. And so the question is, there's really 3 questions that are raised in the briefing. First, as to the employees. 1, does the fact that there are employees that maybe were in the position had they turned their head to see the banana peel make a difference under the statute in any event? And our position is it doesn't. Then
Counsel,
two.
but it
Yes.
is, I'm not sure I understand your position. Is your position that in light of section 768.0755, a plaintiff cannot prove negligence by showing that the defendant acted negligently by failing to exercise reasonable care in the maintenance, inspection, repair, warning, or mode of operation of the business premises?
That's absolutely our position. That there's several cases, Florida cases, including out of this court. I think Glaze v. Worley is the one that addressed the issue that it was in the context of a discovery dispute and whether or not the statute 768.0755 applied retroactively or not. And the issue was whether or not the statute had a substantive change or a procedural change.
But
And in
would
doing
your
that-
interpretation abrogate the well-established duties of care of maintaining the premises in a reasonably safe condition and warning of concealed dangers?
In transient foreign substance cases, the only way for a premises owner in a business establishment to be found liable is with actual or constructive knowledge of the condition. And the statute defines what is meant by constructive knowledge and limits it to the length of time that the substance was on the floor or that it was the result of a regularly occurring condition.
Well then, how do you reconcile your interpretation of the section with its express provision that the statute does not affect any common law duty of care?
Well, I think there are other common law duties of care that a premises owner still has, but the statute, that portion of the statute, that comment at the end, if that were treated as altering what is required to show constructive notice, the statute would serve no purpose. There are common law duties of care that premises owners have, but as to the issue of proving the existence of a transient foreign substance and knowledge as to that existence, the statute expressly limits liability to actual or constructive knowledge, and then also having a reasonable amount of time to take action to remedy the condition. But if I have, it's not the first time I've heard the question of what about this last little section about that there are still common law duties of care owed. The statute's meaningless if that's meant, if that's read to mean that there's still claims for negligent inspection, mode of operation, employment, training of employees. And we have case after case.
But that's not the main thrust of their claim. I mean, the suit primarily asserts that, hey, Walmart knew about the banana peel, had a duty to maintain a safe premises, knew about the banana peel, and didn't clean it up before this happened, and it caused damage. So, I mean, which is a typical premises liability suit. It's just this statute creates an extra fact, or a fact that it must be proven by the plaintiff to get through to the jury on the entire claim, and that is knowledge. And so they have to show that Walmart knew about that banana peel and didn't do anything about it, and then someone slipped on it, right?
Correct.
So, and your motion was, Walmart's motion was limited to, hey, they can't show, there's no evidence that shows that the banana peel was there long enough to constitute constructive knowledge. Which sounds like a dare, mostly. I mean, in respect, I mean, not, I mean, and that's what summary judgment now is it's a dare, like, okay, do you have evidence to show that it was there long enough? But it also raises the question of, can it ever be a question of law that it was there long enough?
Well,
Or is
I
that
think it
for the
can.
jury?
I think there are many cases, none that are at the exact time frame we're talking about here, but there are a series of Florida cases where really 5 minutes, the one.
But how can a judge ever make that determination? Like 5 minutes, 8 minutes, 10 minutes, 12 minutes? How can a judge make that call?
I mean, I guess that my response would be that you could say that about most summary judgments then. And at a certain point, it is considered that as a premises owner, you should be given a certain amount of time and other circumstances can be considered.
But that's a policy question. We mean a premises owner should be given a certain amount of time to do what? To clean up? So judges, as a matter of policy, should say, you know, you should have at least 5 minutes to clean up that banana peel, but only if it's in a certain area of the store. It should be 8 minutes if it's in another area of the store.
Well, this is keeping in mind, though, that the general rule is that a premises owner is not the insurer of the safety of
But it is
all
responsible for
invitees.
the safety of its premises, and if it knows about a hazard, it has a responsibility to clean it up.
Correct, but knowing about the hazard, I guess we're gonna go in circles here a little bit, requires
But that's the point of
knowledge.
the statute. The statute requires that the plaintiff introduce evidence to show and prove that the premises owner had knowledge. And they can do it by actual knowledge, like I said to opposing counsel. Had that Walmart employee turned her head 90 degrees and seen the banana peel, then we were talking about actual knowledge. Instead, as your motion recognizes, this is constructive knowledge, and was it there long enough? It sounds like you're asking the court, and the trial judge obliged, ultimately, to answer your question of what is long enough. And apparently 8 minutes is not long enough.
Well, and there's no Florida case saying that that is long enough, but there are Florida cases just under that amount of time, and there are Florida cases significantly over that amount of time that we're currently at. We're in just under 8 minutes, and it's not just over, it's I think 7:50, is in kind of that murky area right now. This court in Walker versus Winn-Dixie Stores, which is a 2014 decision, 160 Southern 3909, found that when there was evidence that the substance could have been on the floor for as much as 5 minutes, it wasn't enough to create an issue for the jury. The Third District Court of Appeal, I'm sorry, for 4 minutes, not 5 minutes. The Third District Court of Appeal, just a couple of years ago in the Los Angeles versus Winn-Dixie, 326 Southern 3811, found that 5 minutes, even though there was evidence that it could have been on the ground, 5 minutes wasn't enough to create an issue of fact. So there are
So,
several
but
others.
in taking your position, it makes no difference here that the Walmart employees were in the vicinity of the banana peel at the time in question.
Correct. It could make a difference if there was something to suggest actual knowledge and if that had been argued, but not as to constructive knowledge. Constructive knowledge is strictly about the passage of time and whether or not a condition is a regularly occurring condition.
Then,
Why-
go ahead. Not to.
Why does there have to be summary judgment available on a question like this? I mean, as I asked before, there's no constitutional right to summary judgment. Do you agree?
There's no constitutional right to summary judgment any more than there's a constitutional right to be free of summary judgment under the right circumstances.
Well, there's no constitutional right that applies to Walmart. This is not a matter of Walmart having to suffer through trial. I mean, as a matter of fact, I guess it's arguable that Walmart also has a right to a jury trial. But certainly the plaintiff has a right to a jury trial as long as they have some evidence from which a reasonable juror could conclude, in this instance, that there was constructive knowledge, that it was there long enough that Walmart should have done something about it.
Right, and I guess conceivably that could happen, but it didn't happen here. All that happened here was that video evidence was presented that showed one employee walking by that was not directly by, but off to the side, other side of the bin, looked to me like they were carrying their lunch and weren't even on the job, but be that as it may, you know, even assuming that they were working at the time, didn't see it because there's no evidence of actual knowledge. But there are other things, other evidence that could have been admitted to show that the circumstances were such that 7 minutes and 50 seconds was enough time to put the store on constructive notice and create an issue of fact.
Like what?
But that's all that they relied on.
Like what? What other evidence would they have had to show?
Well,
That
if you were talking about a like a little gas station restaurant, which is or a convenience store, like at a gas station, one of those smaller places where there's a spill just in front of the register, whether the employee who's standing behind the register looked or not, after a certain amount of time, one could say that that would be sufficient to create a jury issue. Plaintiff didn't introduce
have
any
to
evidence
offer-
about the specifics of this store. The case out of the Fourth District Court of Appeal, MacArthur versus Broward College, that one involved a slip in an elevator. And in that case, the court said, look, this is a campus. You're going to treat retail stores one way. You're going to treat the size of retail stores a different way. But there was nothing introduced here about this Walmart superstore, which I think can be presumed is a large space, but nothing brought to the trial court to argue about that. The argument was very specific in response to the motion for summary judgment. It was that it was just under 8 minutes, and here's a couple of employees who were in a position that they could have seen it, which, not to be beating a dead horse, but we maintain that's not relevant under the statute.
But it's part of the circumstances. It's something that we're not talking about an affidavit where someone just says, yeah, there was a banana peel there, and you have two other people that say, yeah, I passed by the banana peel, I don't know, 2 minutes before or something like that. You have a video that plays for 7 minutes and 50 seconds, and you see the banana peel fall off the grocery cart, or not fall off, the guy takes it off, and then it's sitting there, and then people walk by for another 6 minutes or whatever. And then you have Walmart employees, not directly relevant, but the tableau that everyone can watch. I don't see how, if someone can view that and say, yeah, I mean, I would go one way, but I can see how someone reasonably could view that under those circumstances and go the other way.
Well,
Isn't that enough then to go to a jury? That's
Not-
what the Constitution guarantees.
Not under the circumstances that we're talking about, only the video of that one area and one employee that walked by not that far away from it. That's not enough. There would need to be more evidence about the store itself. How busy was the store?
But you
How
can
many
see how
employees
busy the
was-
store is. That's for 8 minutes. You can see the people walking by. You can see where it is in relation to the entrance. You can see that it's that opening space. Just as you come into a Walmart, you get your grocery cart, you see the greeter, and then you just walk through, and you have those standalone displays, and that's where it happened. It's right there at the front of the store.
Right. The argument.
Not judging the case,
Right.
but someone can see all of this. That's the beauty of video.
The argument that was presented to the trial court in both the original response to the motion for summary judgment and the motion for rehearing, which they never obtained a ruling on, just proceeded with the appeal. But in the response to the motion for summary judgment was strictly about the one employee that walked by and the couple of employees that they're saying in the video show were close enough, based on where the display was in relation to the entryway. That's the argument. It wasn't that even without any of this, 7 minutes and 50 seconds creates an issue of fact on the issue of passage of time. That wasn't argued in either the response to the motion for summary judgment or the motion for hearing. It was all tied to because these employees, and that's why the court said in the order granting summary judgment, the 8 minutes is irrelevant. You can't rely on whether the employee turned their head or not.
So in your theory, it makes no difference whether the banana peel was on the floor for 1 minute or 10 minutes? For purposes of it becoming a question of
under
fact
my
for the jury?
theory, I'm sticking with this case. Under my theory, 1 minute or 7 minutes and 50 seconds. I'm not going to make it harder for myself by arguing 10.
Well, then, under your interpretation of the statute, that is 768.0755, what theory of liability remains available to a plaintiff in a slip and fall case such as this?
Well, I think the outer parameters have been set at 15 minutes on a transient foreign substance case if you were in a typical retail type of establishment, and that's that MacArthur versus Broward County case, which I'll get the court to cite to.
I'm sorry, whose parameters?
That's that outer perimeter, 15 minutes for sure. Under Broward would, McCarthy versus Broward College at 164 Southern 3rd, 78. That court says that even though on the Broward College campus, 15 to 20 minutes wasn't enough in a smaller retail establishment, that could conceivably create an issue of fact. And we have several cases, including the Walker case and the Los Angeles case I mentioned earlier, that speak to that 4 to 5 minute range and say that's not going to be enough to create an issue of constructive notice. And so anything over 5 minutes, we're in that questionable period. I would submit that 7 minutes and 50 seconds, considering the size of an establishment, and that premises owners are not the general premise that premises owners are not the insurers of the safety, even though they do have certain duties that arise at a certain point, that's not a lot of time. 7 minutes and 50 seconds. It's not a lot of time to correct a condition created by a transient foreign substance.
It's fairly convenient, though, that your assertion of principle is as well. Certainly 750 is not enough, but I don't want to touch 10, because that works out for your client.
Well, I would suggest 10 also. It's nice to use those round numbers, so we could say 10 minutes is really where the cutoff is. The cases
Right, but you
right now say
recognize
15.
But that illustrates just how arbitrary this exercise is, and you're asking us to establish a principle of law in an arbitrary way. Pick 750 because that sounds good, or let's just go with 10 because that's a round number. You know who's typically supposed to make those calls? The jury, because they're a reflection of the community. They decide. That's what the Constitution guarantees. The plaintiff complete his case, play the video, and have them and look at what's going on, and have them decide whether that was enough time under the circumstances with the nature of Walmart and how big a store it is and the employees, whatever else, and decide whether that was long enough. No? I don't.
Well, I think we've already established, and the case law already establishes that arbitrary or not, 5 minutes has been stated in the case law as not being enough time.
Has the first DCA said that?
Yeah, that was the Walker versus Winn
All right.
DC case.
Are we?
Water on floor for 4 minutes.
So if the, how would we be bound by that though, in the sense of, okay, that's that case under those facts. What legal principle comes out of that to say 750 is also not long enough?
Candidly, the most that decision would bind this court would be for 4 minutes. But to your Honor's question about whether there's ever an issue, because when you put a timestamp on it, it's always arbitrary. I do think the court would be bound by taking the further step and saying no amount of time can be properly decided on summary judgment because.
And what's the matter with that? Why is that a problem?
Because there's case after case that already does it for 5 minutes and less. So we're really talking about the area that's above 5 minutes and below 15 because that's a case that from the 4th district, but a case that says 15 minutes could be enough time under the right circumstances. So courts have arbitrarily been doing that. I understand Your Honor's question, but to come out now and to state that no amount of time, as long as it's on the floor and the video's not showing that spill, immediate slip, that there's always a jury question would go against tens and tens of years of Florida jurisprudence on this issue. So the trial judges are allowed to take a look at the circumstances and make a determination. There's just not enough evidence here to suggest that this was on the ground long enough, even though conceivably it could have been on the ground for this long. This case admittedly is somewhat unique because most of the time the video doesn't pick up these substances. It's water, you can't see it. this you can kind of see the little black piece that's clearly the banana peel. So we actually can track the time here. So
Not just the time, but the different angles and where people are coming from, where it is in relation to the store. I mean, I guess that's a question too. Does the fact that this is video change the analysis? Like, would it be a different case if it weren't video?
well, I think it's always a different case when it's not videoed. So yes, it is a different case if it's not videoed, particularly because many times you often have that extra step of it could have been 4 minutes, it could have been 5 minutes, but there's not the definitive that that's actually what it was. It also could have been a little bit longer, but we just don't know.
Because in this
Here we know.
situation, I mean, it's de novo review, because it's summary judgment. The judge watched the video, presumably, and we have the video, we can watch it. And so there's not the same kind of presumption of correctness, I guess, with the trial judge. Because it's like, okay, you saw the video, but we're looking at the video and we disagree. And isn't that then enough? So if we disagree in looking at the video, is it
Well,
worse?
it's a de novo standard review, I can't hide from that. So yes, this court is in the same position as the trial court to look at whatever record evidence was submitted, whether it be a video or photographs or other testimony or documentary evidence. I will note, when you're talking about viewing a video, especially one where there's some work to do to try and get where a plaintiff tries to get the court as far as who was where and when, it's not that clear from the motion for summary or the response to the motion. There's no transcript of the hearing. I don't know we can't tell what was actually shown to the trial court. Clearly the trial court, reading the response, focused on the employee, whether they turned their head, because that's the issue that was really focused so much in response to the motion. And so,
Thank
even
you,
though academically-
counsel. Your time has expired. Thank you so much for your argument.
So I wanted to just touch on a couple of things because I know I only have a minute or two, less than a minute. The Walker case, that is diametrically different than this case. In the Walker case, what happened was the plaintiff testimony in that case was that she slipped on what she herself described as unnoticeable droplets of water on the floor. And the only evidence she had of constructive knowledge of Winn-Dixie was that they had an umbrella rack that was next to it. That was the evidence. And the court obviously went through the machinations of determining that, even if we think we believe her, 1 minute, and they do talk to 1 to 4 minutes, they talk about another case of the third DCA, but they're hardly in Walker is this court saying, we believe that less than 5 minutes, no constructive notice. It is not in that case. I wanted to just mention, because we're talking about summary judgment standard. And just to be clear, under Rule 1.5010, it says that the movement has to show that there is no genuine dispute of finding the evidence that they need to do that. That did not happen in this case. And so from the beginning, this should have been denied. And we would ask that the court reverse it this time. Thank you.
And thank you, counsel, for your respective oral arguments.